Good afternoon and welcome to your 2026 HR Compliance Checkup. Policies, pay practices, and legal updates. Thanks for joining us today. I'm Raleigh Merrill with GTM. In a moment, I'll introduce you to our presenter. But first, feel free to use the questions functionality to ask your questions during today's presentation. You can access it right up there in the upper right-hand corner of your screen. There's a little box with a question mark in it. You click on that and you can ask your question. And then we'll get to as many of your questions at the end of today's presentation. If we don't get to your particular question, we'll follow up with you in the next day. Also, you'll receive an email later today with a link to a video recording of today's presentation as well as a PDF version. Our presenter today is Jennifer Berry, the HR consultant practice leader at GTM. Jennifer brings more than 20 years of human resources experience to the GTM team, including managing and advising on the HR lifecycle for both small to mid-sized businesses and for not-for-profit organizations as well as larger global organizations. Jen's experience includes advising on mergers and acquisitions, HR project management, HR and benefits compliance, cybersecurity compliance, and more. She's led HR and process audits, ERISA audits, employee handbook projects, benefits administration platform development and deployment, as she's also developed and delivered training on HR and benefits compliance. Jennifer has also consulted with clients in all areas of HR, including leave management, talent acquisition and termination, benefits enrollment, compliance, and ACA, HIPAA, and COBRA, and state and federal compliance notices. So at this point, it is my pleasure to turn things over to Jennifer Berry.
Thank you very much, Raleigh, and welcome everyone. If you operate a business in New York State, you're already aware of the annual increases to minimum pay rates and other pay thresholds. So we thought we'd start our update today talking about those areas in New York State. So with that said, let's dive into some of those new rates for 2026. 2026 pay updates start with minimum wage increases. New York, as it has done over the last 10 or so years, has continued to increase the minimum wage across the state. Effective January 1 of this year, the minimum wage was increased to $16 an hour for most of New York State, including for us up in the capital region. For employees in New York City, Long Island, and Westchester County, the minimum wage is slightly above that at $17 an hour. And the minimum overtime rate is based on 1.5 times that minimum wage amount. So make sure that if you do have hourly employees and are paying overtime, that there actually is a minimum overtime rate in the state. Please note that separate minimums apply to tip service workers in the hospitality industry and tipped food service workers in other industries and some home health care workers. Next, additional pay increases are in play for your exempt employees. In order to qualify as an exempt employee, workers have to meet certain duties requirements as well as to be paid by salary and at a minimum exempt salary amount. Please note that New York State has set a higher exempt salary threshold than federal law requires. Employees who work in an executive or administrative capacity and are exempt in New York State must meet the state minimum salary thresholds set by state regulations to qualify for exempt. For most of the state, the 2026 minimum salary threshold is just about at $1,200 per week at $1,199.10 per week. That's $62,000 plus per year. In New York City, Long Island, and Westchester, it's slightly above that, as the minimum wage also was at $1,275 per week, or at about $66,000 per year. Please note that New York does not impose a minimum salary for exempt professional employees. they must be paid at the federal exempt minimum salary of at least $684 per week or $35,568 per year. You can see there's a significant difference in exempt salary thresholds for executives and administrative exempt employees and professional employees in the state. Please note that despite higher federal salary thresholds being proposed for 2026, you may have heard about that, those increases have been abandoned for now. In fact, this threshold remains unchanged from 2019 due to federal courts vacating the Department of Labor rules that would have been increasing these levels. Due to the consistent increase in New York State's exempt salary threshold, employers should be sure to evaluate their exempt employees' pay each year to assure that they are actually considered exempt. Please note if they do not any longer meet the salary threshold at any time, their status will need to be changed to non-exempt, and they will be eligible for overtime on any hours worked over 40 in a work week. It's regardless of their duty. So even if they have a job that would seemingly be exempt otherwise, if they're not making that exempt salary threshold amount, they are no longer considered exempt. Also, if you do not reclassify employees who no longer meet the exempt salary threshold, you could be liable for back pay, including back overtime, interest, and penalties. There is yet another change in New York State for employees required to wear uniforms as part of their work for the employer. The required uniform allowance for employers who require employees to wear a uniform but do not wash and maintain those uniforms itself increased on January 1st. These changes are part of the broader 2026 minimum wage and salary threshold adjustments across New York State. A required uniform is defined as clothing required to be worn while working at the request of the employer or to comply with any federal, state, city, or local law, rule, or regulation. An exception is clothing that may be worn as part of an employee's ordinary wardrobe. Rates noted on this slide are tailored to hours worked and location. For full-time uniformed employees, it may be as high as $19.85 per week. In addition to some of those pay changes, the One Big Beautiful Bill Act, which is the discussion, has been in discussion since the beginning of the year for a lot of employers, introduced the no tax on overtime rule in July of 2025. While it doesn't change how you manage employer payroll, it directly affects an employee's federal income tax liability. There will be some employer reporting responsibilities in 2026 through 2028, which we will discuss in a moment. Due to the Act, federal income tax will no longer apply to the overtime premium portion. That's the half of the time and a half of certain qualifying overtime wages pursuant to the Fair Labor Standards Act, or FLSA. It's actually mislabeled as no tax. It is instead a deduction that the employee is eligible for if they meet other eligibility criteria. This deduction reduces taxable income, potentially lowering federal income tax liability. At this time, it does not exempt employers from payroll taxes, including Social Security and Medicare, nor from state or local taxes. State overtime laws, double time, union contracts, holiday pay premiums, or guaranteed overtime hours that are not directly tied to FLSA mandated hours don't apply to this rule. Please note that tips, straight time bonuses, and hazard pay are also excluded. To benefit from this deduction, the overtime must meet the requirements of the FLSA, typically when an employee works over 40 hours in a 7-day work week. Any additional overtime provided via employer policy or required by state law, if not in New York State, are not subject to this rule. For example, some employers pay employees double time if they work on Sundays or holidays. This deduction only takes into account the 0.5 of the 1.5 pay rate, when calculating the amount. Any additional amounts are not subject to this deduction. For example, if an employee is paid $20 an hour, their overtime rate is then $30 an hour. That extra $10 an hour is the overtime premium and is not subject to federal income tax under this rule. Due to the new overtime reporting rule, eligible employees can deduct up to $12,500 for individual filers or $25,000 for joint filers. The deduction will be claimed when the employee files their personal tax return. As stated previously, this deduction does not impact Social Security, Medicare, or state income taxes. Those contributions remain exactly the same. Please note that this employee deduction applies for tax years 2025 through 2028. For 2025, employers were not required to separately report qualified overtime on the W-2 or 1099. Employees are able to use pay stubs or other employer statements to calculate the deduction when doing their personal income taxes. That means employers will not face penalties for failing to separately provide the total amount of qualified overtime compensation, and that's just for 2025. Also, Form W-2s for this past tax year were not updated to account for the big, beautiful bill related changes. So this past tax year served as a transition period for IRS enforcement and administration of the new information reporting requirements for qualified overtime compensation under the One Big Beautiful Bill. In 2026, however, employers will report an employee's qualified overtime amount in box 12 of their W-2 using code TT. Also, under the One Big Beautiful Bill Act, there may be a deduction for up to $25,000 on qualified tips from taxable income for 2025 through 2028, subject to income limits and occupation eligibility. Qualified tips include those paid voluntarily in cash or charged tips received directly from customers or through tip sharing arrangements. Mandatory service charges are not eligible. This is another individual tax deduction, so does not necessarily affect an employer's tax obligation other than reporting requirements noted. There are income limits associated with this deduction. The deduction phases out for modified adjusted gross income over $150,000 for single filers and $300,000 for joint filers. Married taxpayers must file jointly to claim the deduction. It's also limited by occupation. Only employees in jobs that customarily and regularly receive tips on or before December 31st, 2024 qualify. The IRS has published a preliminary list of 68 occupations across sectors like hospitality, food service, wellness, transportation, and entertainment. So, for example, most wait staff at a restaurant serving food and beverages are eligible for this deduction so long as they meet the income levels. Tips must be reported on an employee's W-2 or a worker's 1099, and employers or payers must provide statements showing cash tips and occupation. In addition to some of those other changes, New York is joining a number of states and now mandating that employers offer employees a retirement plan option. New York's Secure Choice Savings Program requires private employers, for profit and not for profit, with 10 or more employees in the state, operating for at least 2 years, to offer a state facilitated Roth IRA via payroll deduction if they do not already provide a qualified plan. Registration is mandatory for compliance with deadlines starting next month. Employers already offering a qualified plan must still register to certify their exemption. If audited, you will be asked to show proof of that exemption. Employees are automatically enrolled at a default 3% contribution rate, but may opt out or change their rate. It's important to note that employers are not plan sponsors, do not pay fees, and do not provide matching contributions under this state plan. Now, let's turn our attention to some other labor law updates for 2026. The Trapped at Work Act prohibits New York employers from requiring employees to repay costs such as training if they leave the company before a specific period has elapsed. There are certain exceptions to this law for tuition and other limited reimbursements. The governor initially signed this bill as another way to protect workers' economic freedom and professional mobility in New York State. It is so that employees are free to pursue professional options and work experiences without being tied to their previous employer. The act reflects a public policy goal that employers who benefit financially from trained employees should bear the cost of training rather than imposing debt on their workers. This law applies to all workers, including employees, independent contractors, interns, volunteers, etc. There are some proposed amendments to this portion of the law which would narrow coverage to employees only, so we recommend keeping your eyes peeled for resolution of this application. There are certain exceptions allowed under the Act. Payroll advances unrelated to training certainly can be clawed back by the employer. Tuition repayment agreements. If the credential is transferable and not a condition of employment, payment is capped. Other limited exceptions include bonuses and relocation payments. Because of the amendment, enforcement of the act will be delayed until February 2027, so we do have some time to get ready for this. It gives employers time to review relevant policies, offer letters, and agreements for compliance. Next, the Fair Credit Reporting Act received significant updates in 2026, many of which are unrelated to employment. However, the updates we will discuss today impact how employers handle credit reporting and employment decisions. First, employers are prohibited from using an applicant's or an employee's consumer credit history for employment-related purposes, except in narrow exceptions. Employers cannot use, request, or inquire about credit history for hiring, compensation, or promotional decisions. Next, the law will not alter or exempt employers from complying with any local law, ordinance, or regulation regarding the use of credit history if such laws provide greater protection. So keep your eye out for more stringent state and local protections in this area. Employers must update their internal hiring policies and procedures to align with the new requirements and train staff on the new restrictions. With that said, we recommend reviewing your employee handbook policies around hiring, as well as your applications and background check policies around credit. The updates provide employees with a private right of action against employers that fail to comply with the new law. Please note that employers are still allowed to do credit checks for specific roles, including those roles with fiduciary authority or signatory power, those employees with access to sensitive, confidential, and non-public trade secrets, and positions requiring bonding or security clearance. The new provisions of the Fair Credit Reporting Act will become effective this upcoming April, so keep your eyes out for that and start looking at your policies now. New York State now formally codifies disparate impact liability under New York State's human rights law, aligning it with federal Title VII and New York City human rights law updates. Under the amended law, an employer can be found to have committed an unlawful discriminatory practice if a facially neutral policy or practice has a discriminatory effect on a protected class, even without discriminatory intent. Disparate impact occurs when a neutral employment policy or practice disproportionately harms a protected group, regardless of intent. Unlike disparate treatment, which involves intentional discrimination, disparate impact focuses on the consequences of a policy rather than the employer's intent. The new update allows claims without proving discriminatory intent focusing instead on the actual or predictable harmful outcomes of a policy. Policies could include standardized testing, physical requirements, or screening tools. Once policy is proven to cause disparate impact, the employer must prove the practice is job related and consistent with business necessity. Organizations can mitigate disparate impact by reviewing your policies and practices for potential adverse effects on protected groups, using alternative methods that achieve business objectives without disproportionately harming certain groups, and collecting and analyzing data to identify patterns of unintentional discrimination. It is crucial to impact equitable hiring, promotion, and employment practices, ensuring compliance with federal and state anti-discrimination laws, and promoting a diverse and inclusive workplace. New York State encourages employers to add a gender-based violence and workplace policy to their employee handbooks as well. Bidders on competitive state contracts must certify that they have one and will have to provide it when hired on certain jobs. Because the workplace can be a site where the effects of gender-based violence can occur, leading to increased absenteeism, decreased productivity, and higher turnover rates, it has become a priority for New York State and the employers operating therein to make sure you have a policy in mind when contemplating gender-based violence in workplace. New York State mandates that employers implement such policies to qualify for competitive contracts. There is no exclusion to this. You will be asked to show proof of your policies in this area to get consideration for certain contracts. A well-defined policy provides support for employee victims, including access to resources and referral services. Establishing clear guidelines helps foster a safe and respectful workplace culture, reducing the risk of violence and harassment. It also directly supports New York State mandated anti-discrimination and non-harassment workplace policies and sexual harassment training. It is often recommended to involve employees in the development and implementation of these policies to ensure it meets their needs and addresses their concerns in this area. As of December 5th in 2025, the New York State human rights law also explicitly prohibited retaliation against employees for requesting reasonable accommodations for disabilities, pregnancy-related conditions, or religion. This amendment aligns state law with the ADA and the New York City human rights law, protecting against adverse actions like termination, demotion, or reduced hours following a request. Simply asking for a reasonable accommodation is legally protected under these rules, regardless of whether the request is granted. To prove retaliation, an employee must show that they engaged in a protected activity, such as requesting an accommodation, that their employer knew of the request, and that the employee suffered an adverse action casually linked to that request. Sudden negative performance reviews or termination immediately after a request often constitute evidence of retaliation. The law applies to employers with 4 or more employees. If a request is denied, it must be for a legitimate, documented reasons such as undue hardship. New York City is actively considering a Senate bill that would heavily restrict non-compete agreements for most employers. This will also be adopted by New York State if it comes to fruition. However, following a veto on a broader bill in 2023, it's had a difficult time gaining traction, but some similar rules at the federal level and some similar legislation statewide is putting this back into consideration for the upcoming year. The new bill would prohibit non-competes for individuals earning less than $500,000 a year and for all healthcare professionals. The bill would still allow non-competes for highly compensated employees and in the context of the sale of a business. It would also authorize a private right to action, allowing employees to sue and to invalidate non-competes. The bill has passed the Senate, is currently being considered in committee in the assembly. Until this bill passes, New York continues to follow common law where non-competes are enforceable only if they are reasonable in time and scope, protecting legitimate business interests, or do not cause undue hardship. Essentially, New York State, with this and other new law, have come out to say that they are protecting an employee's right to seek alternative employment, and they do not want them to be restricted by these agreements. We are going to move on to some state paid leave requirements. Please note that for this presentation, New York paid leave is the focus. However, we caution you that there are often issues when determining which state's leave laws apply to certain employees, especially if they travel for work or are remote and work in multiple locations. "2026 brings some annual updates to New York State paid family leave. Although employees still have a maximum of 12 weeks of qualifying leave under paid family leave, there are updated rates and contribution amounts. The maximum weekly benefit is now $1,228.53, which is a $51 increase over 2025. The maximum annual employee contribution has also gone up to $411.91, up from $354 in 2025. Employers should update their payroll systems to reflect the increased rate for 2026, while employees planning leave this year can expect higher weekly payouts. Please note that in addition to the 12 weeks of leave and the 67% benefit paid, New York State paid family leave provides job protection and benefits protection over that period of time. There has been even more activity for employers with employees in New York City. As of earlier this week, on February 22nd, the amended New York City Earned Sick and Safe Leave Time Act has significantly expanded employee rights and employer obligations as it relates to time off for safe and sick reasons. In addition to the existing requirement to provide up to 56 hours of paid leave for employers with 100 or more employees, or 40 hours for employers with 5 to 99 employees, in addition to paid or unpaid leave for employers with fewer employees, depending on their revenues, New York City employers are now required to provide a separate 32 hours of unpaid safe and sick time. This new bank of unpaid time off must be front loaded at the time of hire and at the start of each calendar year, and is available for immediate use by employees. This differs from the paid leave previously provided, which can be accrued at 1 hour for every 30 hours worked. In addition to paid and unpaid sick and safe leave, employers must also still provide 20 hours of paid prenatal leave as a separate category of paid time off for all eligible employees. Unlike the paid portion of sick and safe leave across the state, this new unpaid portion, applicable in New York City for now, is not required to be carried over from year to year. The amendments also expand permitted uses to include responding to workplace violence or public disasters, caregiving for a minor child or a care recipient, seeking legal or social services or safety measures if a family member is a victim of workplace violence, and for other uses included in the temporary schedule change law, such as child care closures due to public disasters. Notice of employee rights must be provided to all employees in New York City, both existing and new hires. It must also be posted with other labor law posters. Employer must also provide written earned safe and sick time policies, which must specify both paid and unpaid leave amounts and usage rules. Pay stubs must also show balances, accruals, and use of both paid and unpaid time off. The term protected time off is now used to refer to all earned safe and sick time covered leave. If you employ remote workers in New York City, you should update your policies to include the additional 32 hours of unpaid leave and review the updated expanded reasons for taking time off. You should also make sure your payroll system or provider has updated the capabilities in their payroll system to include 3 separate banks of leave, including paid sick leave, unpaid sick leave, and prenatal leave. Now that we reviewed some of the legal compliance updates and some of the pay requirements, let's discuss creating your HR compliance checklist for 2026, which includes existing and new requirements. It's important to be compliant as soon as you hire a new employee. There are many items to consider when onboarding employees, determining their pay, paying them the correct compensation on the correct frequency, and providing them with your company policies. First and foremost, all employees in New York State should receive a wage notice. This includes their rate of pay, frequency of pay date, and overtime rate if applicable. We also highly recommend utilizing an offer letter to review other details about their position, reporting, and other employee benefits. It is important to determine whether employees are exempt or non-exempt for both the wage notice and offer letter. If you are classifying employees as exempt, be sure that employees are not only performing duties that qualify as exempt, but as we discussed earlier, that they are being paid the correct salary amount at the new salary threshold levels that we discussed. Finally, all new employees should receive a copy of your employee handbook. Be sure to update policies that are affected by the new laws discussed today. If you haven't reviewed your employee handbook or do not have one as of yet, we highly recommend reviewing and/or creating a new one, as there have been a number of new required policies and notices that are usually included in that handbook. With that said, we recommend adding the following to your employee handbook. Updated minimum wage policies. Be sure to also increase hourly rates for any hourly employees being paid minimum wage. Do that right in your payroll system if you haven't done so already for January 1, 2026. You should also include updated exempt salary thresholds noted. You should remove problematic stay or pay language for training. You should make sure your earned safe and sick leave policies are updated to include the new unpaid leave provisions if you have any employees in New York City. You should also update your new hire documents, including applications, background check authorizations, etc. Should there be language related to checking people's credit or any of the other discriminatory items that we've discussed today? We also recommend reviewing non-disclosure agreements, non-competes, and other training reimbursement policies that may become out of compliance sooner rather than later with some of the new laws being contemplated. In addition, you should add the following: an updated accommodation and discrimination policy to reflect the human right law changes. You should coordinate with your payroll provider to be sure accruals are showing correctly on the pay stubs, and that amounts for overtime and tips, if applicable, are showing correctly on the W-2. You should also ensure your policies are compliant with the gender violence requirements, especially if you are seeking federal contracts. In addition to all of these new requirements, it makes sense to review some of the ongoing issues that employers should stay on top of and ensure compliance. For example, New York applies one of the strictest tests for worker classification. Misclassifying employees as 1099 contractors to avoid payroll taxes, benefits, and labor law protections is a frequent and costly mistake, exposing employers to back taxes, penalties, and wage claims. In addition, wage and hour violations are some of the most litigated areas in New York State. Common errors include failing to pay the correct minimum wage, miscalculating overtime, improper tip credits, and not providing the required Wage Theft Prevention Act notices at hire and when wage rates change. Finally, New York has a layered and complex leave landscape, especially when you consider federal requirements such as FMLA. There's New York state paid family leave, there's paid sick and safe leave, there's prenatal care leave, and a variety of other leaves. And there are local leave laws in New York City and Westchester. Employers frequently have outdated policies, fail to post required notices, or don't train managers on proper leave administration or anti-retaliation rules. Please be sure to review your policies, notices, and postings for compliance. In addition, since the New York State pay transparency law took effect in 2023, many employers continue to post roles without good faith salary ranges or job descriptions, Remember, this law applies to any employer with 4 or more employees and covers jobs performed in New York State, as well as remote positions reporting to New York State supervisors or offices. Also, as a reminder, New York employers are required to retain payroll records for 6 years, and many businesses fall short on documenting disciplinary actions, performance issues, leave requests, and accommodation conversations. This lack of proper documentation leaves them exposed in audits for litigation, where the burden of proof often falls on the employer. At this point, I'd like to turn it back to Raleigh for a quick word on a couple of GTM HR consulting services, and then we'll take your questions.
Okay, thank you, Jen. Great presentation as usual. Now, our participants, if you'd like to check your organization's temperature regarding the compliance topics discussed today, or to see what changes you may need to make to your policies and procedures, you may be interested in our HR audit. GTM's HR audits are conducted by one of our certified HR consultants. An HR audit is a risk management tool that conducts a comprehensive review of your human resources policies, practices, procedures, and systems to identify areas for improvement and ensure compliance with legal and regulatory requirements. It's an objective examination designed to identify and remedy the possible exposures you have. We fully assess your HR processes and policies, and any findings can be remedied with our team's assistance. An HR audit can identify and mitigate risks, improve efficiency, ensure compliance, and enhance organization effectiveness. We also offer employee handbook services that can help you with your handbook creation or updates. One of our experienced HR consultants will work closely with you to customize a handbook that meets your organizational requirements. Our team has worked on hundreds of HR handbooks over the years. Our depth of knowledge in workplace policies and best practices ensures that your organization and your employees' needs are taken into account. And you'll have an employee handbook compliant with state and federal laws, giving you peace of mind. All right, now on to your questions, participants. Jen, are you ready to field a few questions for us?
I'm ready.
Well, we have a few questions that came in through our sign up process. We'll get to those first. If you have a question right now and you're on the video live, you're welcome to, again, look for that box towards the upper right-hand corner of your screen. It's got the question mark in there. Click on that. You can put your question right in there. Here's a question that came up. Do employees need to have the 5 days of New York State paid sick leave available as of January 1st, or can it be done on an accrual basis?
Good question. Employees do not have to front load New York State paid sick leave. However, if you have employees in New York City, as we just discussed, you just have to be sure to front load that new additional amount of unpaid hours because that is part of the new law. Otherwise, New York State paid sick leave must be accrued at least at 1 hour for every 30 hours worked. New York State paid sick leave law does require an employer to carry over accrued but unused paid sick leave to the next year. So sometimes that does eventually result in employees having a bucket of paid sick leave available to them on January 1st if they did not use it in the previous year. So that's really the only obligation to make it available as of January 1 is if they have unused paid sick leave that accrued in the previous year, the employer is required to carry that over to the next calendar year, making it available on January 1.
Next question, Jen. How can an employer legally determine an employee's eligibility for the parental leave law?
So we get this question quite a bit, and unfortunately, the answer is very little. Employees are not authorized to ask for proof of pregnancy or pregnancy-related reasons for using this time. They're also not allowed to ask for a doctor's note. Our recommendation is that if a female employee requests time under this leave type, that it should just be granted without question. Employers may not retaliate against any employee or ask them to switch the time appointments under this type of leave. So it's just easier as appointments come up and employees request this time off, just to simply give them the time off and ask that they return within a reasonable amount of time that such an appointment would take place. But no details can be asked or confirmed.
Can an employer, are they obligated to ask the employee if they want to use New York State paid sick leave when they call in sick? And also, a second part to this question, what is the rollover rule?
Okay. So employers may auto allocate New York State paid sick leave for any eligible reason an employee is not able to be at work. So if an employee calls in sick, for example, they can automatically use an employee's accrued and unused paid sick leave for that absence. I actually usually recommend that to employees and employers alike. I always tell employees, save your really fun time off for vacations and things like that, and use your paid sick leave for those sick reasons, whether it be you're actually sick or a family member is actually sick or you're going to appointments that qualify. Of course, some employers do choose to have one bucket of paid time off where the time is all consolidated. In that case, I would be sure to document the time used for sick or safe reasons so that at the end of the year, there's an accurate tally of amounts used for that reason. I usually recommend having a combined leave time option for those employers that like to do so, but I found it easier for employers to maintain compliance with New York State paid sick leave by separating that bucket out, although it is doable either way. And with regard to the rollover rule, I think we kind of touched on it in the first question. Employers are required under the New York State provisions to roll over any accrued but unused paid sick leave from the previous year, which ultimately does make it available for employees on January 1. But that is a provision of the rule, and that is also something that makes it difficult to have that combined bucket of leave, including paid sick leave, because often you don't want to roll over any other paid time off. So hope that answers the questions.
Thank you very much. It does. Next question. Does FMLA apply to part-time employees working less than 20 hours per week?
So I'm going to kind of talk about that in two respects. So part-time employees may be eligible for FMLA. Just because they're labeled part-time does not make them ineligible. But in general, to be eligible for FMLA, an employee must work for the employer for a full year and must have worked at least 1,250 hours during that time frame. If a person is labeled part-time, meets those qualifications, then they are eligible for FMLA exactly the same as anyone else would be that's full-time. If they work a strict 20-hour per week schedule, if you just do the math, that does not get them to the 1,250 mark, so they would not be eligible. So the focus should really be on not so much on the part-time label, but more on the actual hours worked in that year.
Next question. Can fathers use this? It says, we'll have to kind of interpret this a little bit in this question. Can fathers use this to take care of their newborn for bonding time? I assume they're talking about paid family leave. I'm not quite sure.
Yes, I would interpret that to be paid family leave, since that's the only type of leave that we've discussed that fathers are eligible for. They are not, we did touch on the prenatal leave a little bit. Those are only for the mother who is either trying to become pregnant or is pregnant for those appointments. Partners and spouses are not eligible to take time for that. But under paid family leave, both mothers and fathers of newborn children up to age 1 are eligible to take time. It's one of the best leaves that New York State has to offer from an employee perspective, because it provides both a 12-week leave as well as a benefit. So you're getting paid while you are out. So as such, mothers and fathers alike are eligible to take up to 12 weeks over the course of the child's first year of life to bond with that child.
When a remote worker, someone working out of state, when they apply for leave, does the employer offer the leave from the employees or the employer state?
So this becomes tricky, and really it is a little bit of administrative burden for employers. But the leaves that are mandated in a particular state, and it may not even be a state mandated leave, states like California have states that qualify people in certain counties and cities, if you can even imagine. But the leave that is required where the employee actually is and where they're doing their work, or even if it's working remotely from their home, those states' laws would apply in the case where employee requests leave. Some multi-state employers use one policy, often looking at the state that they have employees in that have the most conservative leave laws, and will allow all employees, no matter where they are, to take all of those leaves according to those state laws, although they're not required to do so, so long as they're using the most localized version of that law for those employees. Employers should be sure that their policies are updated to include multi-state policies if they do have multi-state employees. It's a very difficult area to manage for many multi-state employers, especially in states like California, where leave laws vary by city, state, and county. Employers choose to go the unlimited paid off route in those states to often accommodate many of these leaves.
I have a question that came in through the questions functionality here on our screen. And the question is, under the new savings program, are
Mhm.
employers automatically, I'm sorry, take that back, are employees automatically enrolled at a 3% contribution? Do employers have to offer an opt-out form before this program can be enacted? And what is that date?
So the details around an employee's enrollment, there is sort of a default enrollment, which is 3%. But it is on a case by case basis based on the plan set up. If you enroll in the state plan, there are certain notices and rules around that. I can't speak specifically to the employee forms that need to be completed, but right now, employers are going to be responsible for either registering their company as having an existing plan. And if you do have an existing plan, the registration is quite easy. I've done it myself. And they don't ask any specifics about that plan. You can run the plan any way you want, and you simply certify that you have a plan. If you do not have a plan currently in place, you are required to register on the New York State website, and there are some details that lead to certain answers related to the plan. The plan does not offer a lot of options. There's no matching allowed in the state plan. So often seeking the alternatives is a better option both for the employer and the employee. But I encourage everyone who does not have a plan to potentially look into other plans versus being tied to the state plan, which has little or to no flexibility.
Next question. How would you address responsibilities for a sole proprietor operating seasonally with two employees at a temporary regional festival, usually, say, 3 or 4 days at a time? Do you have suggestions there?
Well, unfortunately, most of these requirements do not have exemptions for that work style, that work arrangement, even for temporary workers. You still have to do sexual harassment training regardless. I often do presentations for nonprofits who work with a lot of volunteers, and technically, under New York State's rules, you are required to provide even your volunteers with that training, regardless of the number of times they volunteer. A lot of these other time off rules in the state would also apply regardless of temporary status. So just having people using the term temporary or literally working only a few days a year does not necessarily alleviate the requirement for employers to provide a number of these benefits and protections and policies and leaves. So I would say the majority of what we've discussed today, if it otherwise applies, should be implemented if you're not doing so already. And I would encourage you to ask more specific questions if you have any related to those particular types of employment.
Okay, and I have your contact information coming up in just a little bit here. I'm going to throw in another question. How would a construction safety T-shirt be required? Is it required under the uniform law maintenance allowance?
So the uniform law is very interesting. And if it's a required uniform that someone would not otherwise wear in their personal lives, it's typically considered required by the employer. Now, that's part A. Many employers in industries that require uniforms, such as restaurant and other work like that, they alleviate paying employees for this by saying they're going to be responsible for the maintenance and the washing of such uniforms, making them available for employees when they return to work. As it relates to a construction t-shirt, if it's a required part of the job and it's not something that they would utilize in their personal life, then I would suggest, being on the conservative side, that maintenance amount be paid to the employee. And really, it's meant to just reimburse them for the maintenance of that garment, and to make sure that it's clean when they're coming to work the next day, or if they have to purchase other ones, that they're prepared to show up with the appropriate attire, whether it be for safety or other reasons.
Here's a question. If you operate in New York State but have remote employees living in New York City, does the new sick time rules, do those rules apply
Yes.
in that
Yeah, they
situation?
they will apply. Yep. It doesn't matter what in that case, for this rule, it doesn't matter where their employer is located. It's based on the location of the employee, even if they're working remotely from their homes. So you will be obligated to provide that additional 32 hours of unpaid safe and sick leave under the new rules, and technically it's effective as of this past Monday. So I would encourage you to make sure that your payroll system is accurately including that pay stubs are showing the separate category of time off, and that the various policies are communicated to employees so that they are aware that they now have this bucket of time off to be utilized.
Well, that's all the time we have for questions during this presentation today. Jen, thank you very much for sharing your expertise. Anyone
Thanks,
with
Riley.
additional questions, thank you. You did a great job. We appreciate you. And if you have additional questions, you can reach out to Jen, and her contact information is right there on the screen. And then if you're interested in learning more about GTM's leave management, HR audit services, handbooks, any of that kind of stuff, you can also reach out to Andrew Gowinski, and his information is right there on the screen as well. We'll leave that up for a bit and say thank you to all of you for joining us today. We had a nice turnout. We'll be sure to look for that email that's coming from us. It's got the link to today's video, so you can review this again if you like, or if you'd like to see it in a PDF version, that'll be sent to you in this email as well. Enjoy the rest of your day, and thank you for joining GTM.